Any mention? Any mention?
May please, Your Lordship. Your Lordship, I beg to mention item number 4 and 5, Your Lordship. Your Lordship, in this matter, the petitioners are relying on a judgment, Your Lordship, and the same case is pending before the division bench, Your Lordship.
You're for?
I'm for the respondents,
Who's
Your
for?
Mr. M. Chanda.
Then
Your Lordship, I've already taken consent from him.
taken his consent?
Yes.
2 weeks?
Yes, Your Lordship.
4, 5, 2 weeks.
Much obliged.
Please, Your Lordship. Your Lordship, I beg to make mention of item number 8. Your Lordship, I humbly pray for 2 weeks' time in this matter as the leading counsel, Mr. Elsim, is indisposed, Your Lordship.
8, 2 weeks.
Very obliged, Your Lordship.
My lord, item 7, my lord, there's a connected matter. They may be tagged together, my lord.
Item?
This is item 7, my lord. 7 of the hearing list, my lord. This is FAO number 11, my lord. Same issue was taken together even in the trial court, my lord. Maybe tagged together, my lord. Same.
With
I'm
what?
for the respondent, my lord. In this
No,
case.
this is same
7. Hearing
7
list.
and what?
7, my lord. The other matter is listed after 3 weeks, my lord. FAO.
In this court?
Yes, my lord.
Yes.
Same, it's a connected matter, my lord.
Okay.
I'll just hand over the last order, my lord. Can be taken up together, my lord. Can be
Yes,
tagged
yes.
together, my lord.
Definitely, it would be
The same-
convenient.
My lord.
Oh, 10, 11.
My lord.
Same parties.
Same parties, my lord. Originating from 2 wills and more,
Okay.
can be tagged together. My lord. Same time can be listed. I think 2nd of July, if I'm not mistaken, my lord.
Second July.
July. As prayed for by the parties, this is matter on 2nd July.
Obliged.
Daily list item number 1.
May it please your lordship, I'm praying for 2 weeks' time in this matter, as we are awaiting for confirmation from the department regarding striking off the name of respondent number 3 from being a parties.
2 weeks.
2 weeks' time.
Mr. Learned Counsel for the applicant has sought for some more time to seek instructions in this matter. Accordingly, as prayed for, this is matter after 2 weeks.
Highly obliged.
Item number 2.
Matter has been
Lordship,
matter has been heard.
it has been heard, Lordship. The state is supposed to start its arguments, Lordship.
This is a Waqf board matter, Lordship.
Is that
Lordship,
committee?
constitution of
Constitution of the
board,
Waqf
Lordship, Waqf board.
Yes, Mr. Karim, you start.
Lordship. Please, Lordship. Lordship, the main grievance in this writ petition, Lordship, is with regard to the eligibility criteria of the members of the newly constituted Waqf board, Lordship. The contention of the petitioner in this writ petition, Lordship, is that the members of the newly constituted Waqf board do not have the requisite qualification as per the Act, Lordship.
You're for state.
I am for the state, Lordship.
Yes.
So, Lordship, here, Lordship, the grievance, the main grievance of the in this petition, Lordship, is regarding the eligibility criteria of the members of the newly constituted Waqf board. The contention of the petition is that the members of the newly constituted Waqf board do not have the requisite qualification as per the Act, Lordship. Lordship, I'll take your Lordship to paragraph 6 of the writ petition, Lordship. Paragraph 6 of the writ petition. Paragraph 6 to 12 of the writ petition, Lordship. Paragraph 6, I may read, Lordship. Paragraph 6, Lordship, of the writ petition.
Page.
Page 15.
Yes.
Paragraph 6, page 15. The petitioner states that the petitioner number 1 by representation dated 18/8/2022 had earlier intimated the respondents that the constitution of the board was in complete violation of section 14 of the new act and rule 4, 5, 8 and 9 of the Waqf properties lease rules for 2014. Further, several members of the board who were selected did not have the requisite qualification. Paragraph 7. The petitioner states that to the surprise of the petitioner, the respondent by impugn notification dated 5/01/2023 reconstituted the board, and by notification dated 23/01/2023 partially modified the notification dated 5/01/2023 and constituted a new board. The petitioner number 1 by representation informed the Secretary Social Welfare Department that the constitution of the new board was in violation of section 14 of the new act and the Waqf property rules. Further, it was informed that some of the selected members did not possess the required qualification. That the petitioner stated that despite submitting representation before the respondent authority, the respondent, without considering rectifying such irregularities and illegalities, the respondent are till date functioning with newly constituted board, which is in violation of provision section 14 of the new act. That the petitioner submits that the constitution of the Waqf board, the respondents are required to strictly adhere to the mandatory provision of the section 14 of the new act. They submitted that in the instant case, the respondents admittedly constituted a new board which comprised of members who do not possess the requisite qualification prescribed in the section 14 of the new act, therefore essentially deviating from the statutory provision section 14 of the new act. Section 10, that the petitioner submits that the action of the respondent in notifying and constituting the board by notification dated 05/01/2023 and notification dated 23/01/2023, despite being well within their knowledge of the qualification and the requirements prescribed in section 14 of the new act, casts a shadow of nepotism and formation of board with people who are in their good books to suit their interests and ulterior motive. It is most humbly submit that when a statute prescribes certain requirements, the same has to be adhered strictly and there cannot be any deviation from the same. In the instant case, the respondents dominated the selected members of the board despite being aware of the fact that some of the members do not have the requisite qualification or otherwise do not fulfill the criteria as required under section 14 of the new act. So, Lordship 11 and 12 is the same. The challenge is mainly on the qualification, requested qualification of the members of the Waqf Act or Waqf Board, Lordship. Coming to the Coming to the relevant provision under the Work Act, Lordship, relating to this instant case. First, Lordship, I will take you, Lordship, to Section 13. Section 13, Lordship. Relevant provision and under the Act. Section 13, Lordship.
13.
13(1)(3).
Yes.
Section 13.
Yes.
This provision, Lordship, provides the power to the state government to establish a Waqf board.
Yes.
It provides the power to the state government to establish a Waqf board. Section 13. Incorporation. Subsection 1.
Yes.
With effect from such date as the state government may by notification in the official gazette appoint in this behalf, there shall be established a board of Waqf under such name and may be specified in the notification. So this is the power to establish a Waqf board under this Act, Lordship. And now coming to Section 14. Section 14, Lordship. Relevant provision. Section 14.
Yes.
Section 14, subsection 1. This subsection prescribes the composition of the state Waqf board.
Yes.
This is regarding the composition of the state Waqf board, Lordship. It is very lengthy, Lordship. It consists of the chairperson, and from clause B onwards, all the other members are laid down, Lordship. Composition of the other members are laid down. And coming to subsection 2 of section 14. Subsection 2 of section 14. This provision lays down the procedure for election of the members.
Yes.
Subsection 2 of section 14, Lordship. It lays down the procedure for election of the members of the Waqf board.
Yes.
Lordship. Section 14, subsection 2, Lordship.
Yes.
Kindly come to subsection 2, Lordship. Election of the members specified in clause B of subsection 1 shall be held in accordance with the system of proportional representation by means of a single transferable vote in such manner as may be prescribed. So this is procedure regarding election, Lordship. Now subsection 3 of section 14 is also there, Lordship. Subsection 14 of section 3 of section 14.
Yes.
Lordship, I may read it, Lordship. Subsection 13. Notwithstanding anything contained in the section where the state government is satisfied for reason to be recorded in writing that it is not reasonably practicable to constitute an electoral college for any of the categories mentioned in subclause 1, 2, 3 of clause B of subsection 1, the state government may nominate such person as the members of the board as it deems fit. So, Lordship, the government has taken recourse to this subsection 3 of section 14. For reason, here it provides that if it is not possible to constitute an electoral college for any of the categories mentioned in subclause 1 to 3 of clause B of subsection 1, the state may nominate such person. So the state has to, if the state takes recourse to this subsection, Lordship, it has to
subsection 3.
Yes, if the state takes recourse to this subsection 3, it has to record a reason.
Yes.
So what is the reason, Lordship, why the state has taken recourse to this subsection 1? Now, Lordship, I'll take your Lordship to the notification, the impugned notification. Impugned notification at page 23 of the writ petition. Why recourse was resorted to this subsection 3 of section 14? Lordship, page 23, annex 1 of the writ petition.
Yes. Yes.
Lordship. the third paragraph at the bottom from the top. This is notification, MP notification dated 5 January 2023.
Yes.
So this is the third paragraph. And whereas the state government is thus satisfied that it is not practicable to constitute the respective electoral colleges for the purpose envisages, hence resort to the provision of subsection 3 of section 14 of the aforesaid Act. Now therefore, in exercise of the power conferred under subsection 14 of the said Act and all enabling provisions on that behalf, the government of Meghalaya hereby nominates and appoints the following persons to be members of the Waqf Board. Lordship, I'll read from the beginning, Lordship. I'll read from the beginning, Lordship. From the beginning. In exercise of the powers conferred by subsection 1 of section 13 of the Waqf Act, as amended, the government of Meghalaya is pleased to reconstitute the Meghalaya Board of Waqf with effect from the date of its publication in the official gazette. Whereas some of the members of the Meghalaya Board of Waqf to be appointed from amongst the Muslim MPs and Muslim MLA, the Muslim Bar Council members and the Mutawali of certain Waqf are to be elected by the electoral colleges of the respective categories. And whereas there are no Muslim MP or ex-MP from the state, B, there are only 2 Muslim MLA in the State Assembly. Number 3, the Muslim advocates of the Bar Association have however agreed to co-opt members from amongst them to be the members of the Meghalaya Board of Waqf. So this is the reason why it could not conduct the election. As per subsection 2. Why the state could not conduct the election as per subsection 2 of the Waqf Act. This is the reason given in the notification, Lordship. There are no MPs and no ex-MLAs and only 2 members, and also the members, Muslim advocates of the Bar Association have co-opted members from amongst them to be member of the Waqf Board. So the reason is recorded in the MP notification itself, Lordship. Now, Lordship, after the expiry, the term of the previous Waqf Board, Lordship expired after the expiry of the term of the previous Waqf Board, Lordship. The department received three independent representation.
Yes.
From the members, from 3 members of the earlier Waqf Board, Lordship. So, Lordship, after looking into these proposals and representation, the approval was sought and the notification dated 05/01/2023 was issued, reconstituting the new Meghalaya Waqf Board, Lordship. These representation are at page my affidavit, Lordship. I have enclosed in my affidavit, Lordship, the 3 representation and proposals from the prominent members of the Waqf Board. Page 10 of my affidavit, Lordship. These proposals were examined by the page 10 of my affidavit, Lordship. 3 independent proposal. Page 10, Lordship. Page 10 of my affidavit. Yes. After examining these proposals, Lordship, the approval was sought.
This 14 March.
Yes, Lordship, 14 March 2022.
From this
This is
Mohammed?
from one
Yeah,
from CEO. CEO.
Okay, CEO.
CEO, Lordship. Lordship, this is addressed to the department, Social Welfare Department. With reference to the above cited subject, as per notification and reference, this is to inform you that the existing board of Meghalaya State Work Board will be completing its tenure on 16 March 2022. The notification of the board members were made on 16 March 2017 for a period of 5 years, so expired. It is therefore requested to reconstitute the board for a period of 5 years with a member selected and this is some word is missing here. As per section 14, 15, 16 provided in the provisions of the Work-up Act 1995 for selection of members to the board. This enclosed list has approval of the chairman for better and smooth functioning of the board. This is one representation, Lordship, and enclose also the name of the suggested names of the members proposed of the members. So another representation at page 13, Lordship. Another representation at page 13, Annex 2.
Page 13.
Yeah, page 13, Annex 2. This is from one member of the work board. Formation of the newly Meghalaya Work Board. With reference to the subject cited above, I would like to send a new proposal for the formation of new Meghalaya Work Board, as the previous board's tenure was notified in the official gazette on 22 March 2022. The following names are recommended according to the criteria required under subsection 3 of section 14 of the Work-up Act 1995. So the names are given there. The names of the members proposed to be selected for the new work board. And the third representation on the next page, at page 14, Annex 3, page 14.
Yes.
This is from one. He's Dr. A.M. Qureshi. Yeah. Commissioner, composition of Meghalaya State Work Board. I have the pleasure to request you that in terms of the provision section 14 of the Work-up Act 1995 as amended up to date, hereby propose to constitute the State Work-up Board with the following members. So it is the members are given there. It is therefore requested that the above proposal may be considered for the sufficient functioning of the board. So these proposals were examined by the department, and after obtaining the approval, the notification dated 5 January 2023 was issued, reconstituting the new worker board, Meghalaya Worker Board Lodge. Yes. And thereafter there is one notification is issued, subsequent notification issued dated 13/01/2023 Lodge. Subsequent notification.
Which?
It's in the writ petition, Lordship. This subsequent notification dated 13 January 2023. Page 25, Annex 2 of the writ petition.
This is a modification. Modification.
Yes, this is the notification 13 January 2023. Subsequent issued subsequently. This is the notification, Lordship, issued to correct the first notification dated 5/01/2023.
Yes.
This is the notification issued to correct the first notification dated the main notification, Lordship.
Yes.
Dated 05/01/2023, wherein the name of one woman member was mentioned twice, Lordship.
Okay. So
the name it is a correction.
R.A. Begum.
Yes, the name of one woman member was mentioned twice.
Nothing material.
Lordship.
Nothing material.
Yes, but this is just it's a correction. This is at mentioned twice at serial number 4 and serial number 10, Lordship. It has been corrected and replaced with another name.
Okay.
At serial number 10. Serial number 4 is this Roshara Ara Begum.
Yes.
And at serial number 10 it was repeated.
Yes.
And this notification was issued to correct this mistake. And at serial number 10 the name of another member was replaced. And this is the name is Miss Shanaz Abbas, woman member.
Okay.
Replaced with the name of Shanaz Abbas, woman member. Lord. So but the other members remain the same, Lordship. The other members in the main notification remain the same only. There is no change. Only these correction only. That is the only correction. There is nothing wrong with this subsequent notification, Lordship. And coming to the representation filed by the petitioners, Lordship. This is the notification dated 18/8/2023. Notification dated 18/8/2023. Yes, it is. It is at page 26, Lordship. This is the notification filed by the petitioner at 18/8, dated 18/8/2023. Filed by Muhammad Shabas Qureshi. This is the representation. Your Lordship got it. At page 26 of the petition, Lordship.
Yes, yes.
This is the representation filed by Muhammad Shabas Qureshi, Lordship.
Yes.
Earlier, Lordship, he was the petitioner number 1 in this instant petition, Lordship.
Okay.
He was a petitioner number 1 in this instant petition, but subsequently he has withdrawn himself from this petition.
Okay.
There is an order of this court to this effect, Lordship. This person who filed representation, he has withdrawn from this petition. He was petitioner number 1. Originally, there were 2 petitioners, Lordship. This person and the current petitioner. This petitioner number 1, he withdrawn himself. My submission, Lordship, is that in this representation, Lordship, the averments are very big and general. It does not specify how and which member of the newly constituted committee board does not possess the requisite qualification as per the Waqf Act. It is vague and general. It does not specify which member does not possess the qualification, the requisite criteria as per the Act. It is very vague and general. So difficult to take action on this. So this is my submission on this representation. Now, Lordship, coming to the criteria, the requisite criteria of the members of the board. Lordship, I'll take your Lordship again to the Act, Lordship, Section 14. I'll take for just another 5 minutes, Lordship. I'll take your Lordship to Section 14 of the Act, Lordship. This is regarding the requisite.
You have already taken.
No, the criteria, education. The requisite criteria of the members, Lordship. Section 14.
Yes.
Section 14, Lordship, yes. Composition of the board. A, Lordship, chairman.
Yes.
A, chairman, and B, 1 and not more than 2 members as the state government may think fit to be elected from each of the electoral college consisting of Muslim member of parliament from the state, or as the case may be of the union territory. Then this is subclause 2, Muslim member of the state legislature. Then 3, Muslim member of the bar council of the state concerned or the union territory. Provided that in case there is no Muslim member of the bar council of the state or the union territory, the state government or the union territory administration, as the case may be, may nominate any senior Muslim advocate from the state or the union territory. Number 4, mutawali, having an annual income of rupees 1 lakh and above. Then clause C, 1 person from amongst Muslim who has professional experience in town planning or business management, social work, finance or revenue, agriculture and development activities to be nominated by the state. Then D, 1 person each from amongst Muslim to be nominated by the state government from recognized scholars in Shia and Sunni Islamic theory. E, 1 person from among Muslim to be nominated by the state government from amongst the officers of the state government not below the rank of joint secretary to the state government. Provided further that at least 2 members appointed on the board shall be women. Provided also that in every case where the system of mutawali exists, there shall be one mutawali as member of the board. So these are the requisite qualification under the Act. So now I'll take Lordship to the notification. Notification, Lordship. The main notification, Lordship, in the writ petition, page 23 of the writ petition, Lordship. Page 23, Lordship. Yes. Page 23 of the writ petition. This is the main notification dated 05 January 2023. Number one member, name of member, category, appointment, and this is provision, relevant provision. And number one, Muslim member of Meghalaya State Legislature. And then number two, Muslim member of the State Legislature. Number three, Muslim member of the Bar Council. Number four, Muslim member of the Bar Council. Number five, Mutawali of Waqaf. Number six, Muslim professional experience in town planning or business management, social work, finance, or revenue, agriculture and development activities. Number seven, Dr. M.D. Shah Noor, Muslim scholar in Shia and Sunni Islamic theory. Number eight, Muslim officer of the state government. Muslim officer of the state government, not below the rank of joint secretary. And number nine, women member. Number 10 also women member, because the Act says at least two women member. So my humble submission is that this notification, Lordship, it complies to the requirement under the Act, Lordship. It met the requirement of the Act. This notification, there is no illegality or anything as such. It complies the requirements under the Act, Lordship, under Section 14 of the Act.
Yes.
There is no illegality in it.
Yes.
It is complied in each and every requirement.
Yes.
Like as for instance, Lordship, this I'll give the instance for Dr. Shanur Mehraman. He's a MA PhD in Islamic history and culture. Roshan Ara Begum is a Muslim member of Bar Council. These are the requirements, Lordship.
Muslim member of Bar Council. This is the one which double
Pardon,
name.
Lordship?
This is the one with double name.
No, not that.
4 and 10 are same.
4 and 10 and same.
Person.
That has been corrected.
Exactly.
But the subsequent notification.
Exactly.
Yeah, it has been
That's
corrected.
all.
No, I'm just.
So see, in this committee, she continues to represent, the committee as a Muslim member of the Bar Council.
Yes, Lordship, yes. And two women members. Two women members at serial number 10
So
and
10, that one have.
yes, corrected.
That
That
one
is
has
there.
Yes.
So at least two women members. That is complied. That is met, Lordship. The requirement is met. So in my humble submission, Lordship, there is no illegality in the notification, Lordship. There is no illegality in it, and all the requirements have been followed under the Act. All the requirements have been followed, and that recourse was taken to subsection 3 of section 14. There was no election because there was no, for some reason, the reason is recorded in the notification itself, Lordship. There was no MP member, and also there was no ex MLAs were there, but the existing one is not there. The sitting MLA is not there. So these are the reason the procedure under subsection 2 could not be complied, Lordship. So it was taken recourse to subsection 3. So this is my submission, Lordship. That's all. And Lordship, one more point, Lordship. This instant petitioner, Lordship, he's not affected in any way, Lordship. He's not affected in any way, nor his rights are being violated. Lordship, he just agreed because some of the members from his group are not selected. So that's why he has filed this.
Okay.
And one member has withdrawn.
Otherwise,
He is not agreed party at all.
The selection was in order.
Yes, Lordship. This instant petitioner is not aggrieved. He's not an affected person also, Lordship. He just came and filed this because some of his person from his groups were not selected. That is the reason. That is my submission, Lordship. That's all, Lordship.
Yes, anything? Who else responded?
Private respondent.
Private respondent, Your Lordship, 5 to 8 and 11 and 12. We have already submitted our.
Similar to another one here.
No. Lordship, what I'm praying is, Lordship, let it be fixed sometimes next week for a short rejoinder by learned senior Lordship, and then we'll also place some authorities on this issue, Lordship, and then we can submit our.
They said they have completed the submission. Now they were
rejoined to my learned senior friend, Lordship. Small, it may take, Lordship, 10 to 15 minutes, Lordship, hardly, and we'll also place some authorities on this issue, Lordship, and then we can submit the written notes of arguments, Lordship, subject to Lordship's convenience, Lordship.
Heard Mr. H. Kharmi, learned additional senior GA for the state respondent 1 and 2.
Yes, Lordship.
1 to 4. 1 to 4.
1, 2. No, 1 and 2, Lordship. 1 and 2. 1 and 2 only, Lordship. The rest are these selected members.
Private respondents.
Private
You are
respondents.
appealing for all.
No, Lordship, I'm for 5 to 8, 11 and 12.
What about 3? 3 and
3 is both.
3 and 4 is.
then who's appearing for 4?
Same should be same only.
Let's take 1, 2, 3, 4 should be same.
3, 4 both should be same. Should be same only, Lordship.
They are the member, no?
Because these are the members. CEO also is as serial number 6.
Lordship,
CEO.
the notice were issued, Lordship. It was received by them, but some of them have not entered appearance, Lordship.
Okay.
It was
Here
on
is-
that.
And you are for 4, 5
5 to 8, 11 and 12.
and
5, 6, 7, 8, 11 and 12.
okay, so 3 and 4 they walk both.
He is no longer, na? Yeah. I'm going to say.
They should have been represented.
They are the same members.
Same number.
Same members
Same
mean-
only, Lordship.
Same members mean what?
Yeah. I'm going to say, na? This serial.
See,
This
whatever, see, as far as respondent 3 is concerned, is the work board. Somebody should represent the work board. You can't say same.
because 6 and 7 is
Maybe
CEO.
the CEO would have represented.
CEO is he's a member, Muslim member,
No, CEO.
Muslim member of Meghalaya Legislative Assembly. He's a elected member.
No, he's the CEO.
CEO.
Is he also in this? Yes, Mr. Chanda, what is this?
Lordship, Lordship, if Lordship comes to order dated 30/10/23, Lordship. Lordship. Notice was affected, but they failed to appear, Lordship.
Yet he's not selected. No. All these are all the private respondents are all selected members except this respondent number 9, Lordship. Respondent 1 he is not selected. Otherwise, all are selected members. Well.
But there's no order pass.
Lordship.
No ex parte orders pass.
No, Lordship. After that, Lordship.
Have they initially entered appearance?
No, Lordship. No, Lordship. No, Lordship.
Then have you, then notice has been affected?
Lordship has been affected, Lordship.
You have filed your affidavit of service?
We have filed, Lordship. We have filed our affidavit.
Then you should have made a, your submission for proceeding ex parte against them. You see, at this stage when
Lordship.
they are still, in the fray,
Lordship.
they have to be heard.
Now, these selected members, Lordship, my humble submission, Lordship, they are
Lordship,
the
essentially
board
these
only.
are
They are the board now.
state representatives, Lordship. Otherwise, also these has to be represented by the state, Lordship.
But
Lordship.
see, the point is that there must be some formal
Lordship.
indication
Lordship.
that they are represented by so and so, so and so. If there is no, see what happens is if an order is passed, so it's passed ex parte against them.
Lordship.
Now, if at some point of time they come, if the, I'm not saying anything, perchance the, the order goes against their interests, and they say we have not been heard. What do we do? Until and unless a specific order is passed for ex parte, and they are aggrieved by that, they, they file application or whatever. Then
They will not be agreeable, Lordship, because
Whatever.
these selected members, they are the board now.
True.
Lordship.
Anyway, Mr. S. Chandra, learned counsel for the petitioner, has sought for some time to respond to the set argument, of the state respondent. On a query by this court, as regard the status of respondent 3 and 4, respectively, the learned counsel for the petitioner has submitted that though notice has been effected upon them and an affidavit of service filed before this court in this regard, however, till date, these two respondents have not been represented in these proceedings. It is therefore prayed that ex parte, that this matter may proceed ex parte against such respondents. Next, as has been submitted and on perusal of the proceedings before this court, since the matter has reached the fact end of its conclusion, the respondent number 3 and 4 and 5 not having
minus 5
so 3 and 4 not having appeared before this court till date, it is deemed, therefore the matter shall proceed ex parte against them. As prayed for, this is matter up to 1 week.
Yes.
Item number 6.
May it please your lordship, I'm praying if this matter can be taken up after 2 weeks. Praying for an accommodation today due to the paucity of time.
Matter has not been heard.
Not yet, your lordship.
2 weeks.
Highly obliged, lordship.
Item number 9.
So 10, 11 together.
Together, my lord.
It's not quite 11 too.
My lord, we start from item number 11. My lord, the contentions raised by the petitioners here, in the last occasion they have argued that the council has violated section 7, first proviso. Number 1. Number 2, council also has violated section 8 of the Act. Council also third violated section 9 of the Act, and council also violated section 25. And so far as the first writ petitioner, item number 11 is concerned, which is the main one, main contention is, my lord, he is emphasizing on the importance of section 7, as well as section 8. My humble submission is section 8, my lord, 8, 9, and 25 are pressed by the petition number 2, the acting deputy chief. Because ultimately, my lord, when the chief is removed or suspended, he has a lesser role to play with regard to appointment of the acting chief. Now, therefore, in view of that position, deputy chief came forward and filed a second writ petition. Now, the issue raised by the petitioners, including the pleadings between the parties, raise a very significant issues where lordship may need to address this. Therefore, my lord, one would like to see, my lord, I would take up importantly 5 issues. Number 1, my lord, the suspension, power to suspend pending inquiry is the inherent power of any appointing authority. Number 1. Number 2, my lord, the word suspension mentioned in section 7 do not include suspension pending inquiry, but only confines to suspension by way of punishment. Number 3, my lord, the section 8, which emphasized by the other side. Section 8, my lord, create a space for executive committee to exercise discretion when it comes to appointment of the acting chief. Number 4, my lord, petitioners, number 11, he cannot raise the jurisdiction of the executive committee saying that we cannot proceed towards, because he has participated in the Somoto proceeding throughout, and he never raised this. And another point, my lord, section 9 only operates at the time of appointment and nomination of a deputy chief. It has no connection with the appointment of the acting chief. And the other point, the last point, is section 25. Well, section 25 has been not violated by the council. Now, here it has no customary connection with the matter. Now, here, lordship, can you see the relationship between the chief and the council has nothing to do with the customary. It is only a statutory relationship between the chief and the council. Now, we derive this from the Act itself, and what is the status of the chief? That has to be appreciated, my lord, before we apply that one. Because the relationship between him and the council is, my lord, statutory in nature on the principle of, my lord, master and servant relationship. Now, the status of the chief, my lord, this is not said by council, district council or others, but it is said by the Honorable Apex Court, that the status of the chief is nothing less than the administrative officer of the council. His status, my lord. Therefore, the status which he enjoyed prior to the arrival of the Constitution of India is completely different from the arrival of the Constitution of India under the 6th Statute. Now, therefore, his relationship has to be examined from the perspective of the service law. What is the service law on the suspension? And I would place those relevant decisions. The judicial review
But
on
you see,
this.
Mr. Changchu, as far as this aim is concerned,
Yes.
this is a unique situation.
Yes.
We are very much aware of that. Where is the equation
Yes.
of a master-servant relationship?
I'll come to that.
Statutory
Right.
appointment, Mama.
I'll come to
by
that.
election, by way of election.
I'll come to that. But he is elected, no doubt, by the eligible voters. But he is appointed by the council.
Yes, appointed.
So when he is appointed by the council, now the relationship between him and the council is statutory in nature. Election is customary by the electoral colleagues as per the custom. That council has nothing to do with that. But his relationship for his appointment, obtaining sanad from the council, is purely statutory in nature. And therefore, the issue has been settled by the Supreme Court in that Dikazi case, my lord. Dikazi case. I'll come to that one, my lord. Lordship, kindly see, last time I've given the compilation.
Yes.
Well, this is very important. The status of the chief has been clear by the Supreme Court. Now, what happened in this Dikazi case, my lord, after, my lord, coming in force of the Constitution of India, he was appointed by the chief of the Millennium, was appointed by the governor. And after that, my lord, the council came into being, 1952. The council became the authority to appoint. There was a suspension of the Germanic SIM, the earlier SIM, and he challenged before the Guwahati High Court, saying that there is no provision for removal and suspension. This was argued, and the Guwahati High Court held that the sixth schedule, my lord, sixth schedule do not include suspension or removal. So the action taken by the council was nullified by the Guwahati High Court. Matter to reach the Supreme Court, and when the matter was decided in 1962, by that time, my lord, Appointment of Succession Chief Act 1959 was already in force. Now, leaving aside that 1959 Act, Supreme Court clearly held that the appointing authority was the governor. Now, after formation of the Autonomous District Council became the appointing authority, and by virtue of the fact that they are the appointing authority impliedly includes the power to suspend, remove, or terminate from the post on a reasonable ground, on proper grounds, on the terms of his sanads. Supreme Court says now. My lord, kindly see the relevant para. I would quote, my lord, para 8, 9, 10, and 12. In the compilation, but for convenience,
There's a Dikazi case.
Dikazi case. Because my esteemed colleague has argued last time that this Dikazi case is not relevant to this case. Therefore, I say that with due respect to his submission, I say that it is a very relevant.
Para?
Para 8, 9, 10, and 12. My lord may take note of it.
Okay.
My lord. Para 8, my lord. We have already observed that the administrative powers of the chiefs as they existed before January 26, 1950 came to an end with the coming into force of the Constitution. And during the transitional period, all administrative powers vested in the governor, which could be exercised by those appointed by him under his powers under paragraph 419 of the 6th statute. It is in this background that we have to consider the notification March 6, 1951, that is the action taken by council. That notification notified for the general information of the subjects of Millennium Sameship that government, after careful consideration of the nomination made by the Mandri electors of the successor to the Sameship of Millennium, and also of the objections to this nomination, had appointed the respondent as Same of Millennium in place of late U. Sansat Raja, subject to confirmation by the district council when that body was constituted. It was also notified that the respondent had taken over charge of the CMship with effect from March 5, 1951. It is clear from what we have said above that the Mantri electors in this particular case used to elect a person, and to their election amounted to a nomination of that person for the approval of the governor to the same job medium. But until the governor approved of the nomination, appointed the person so nominated to the same ship, he could not hold office as CM of medium. The position, therefore, just after the coming into force of the Constitution was that the governor was charged with the administration of the autonomous district till the district councils came into existence, and that carried with it the power to appoint officers to carry on the administration. The appointment, therefore, of the respondent as CM of Milliam was made by virtue of the governor's power under paragraph 19, and the respondent derived his power as CM from that appointment and could not claim any power outside that appointment. The governor, of course, made it clear that the appointment was subject to confirmation of the district council when it came into being, for the governor's powers at the time of the appointment were derived from paragraph 19 and are transitional only. That is why it was said that the appointment was subject to confirmation by the district council. Therefore, when the district council came into existence in June 1952, it in due course, in exercise of its administrative powers under paragraph 2.4, considered the question of confirmation of the appointment made by the governor in 1951 and confirmed the respondent's appointment as CM of Milliam and communicated it to him along with the terms on which the confirmation was made. Besides the financial clauses, one of the terms provided that the CM shall be subject to the control of the district council and shall carry out all the orders issued to him from time to time by the district council or its officers acting for on behalf of the district council. It was also provided that the CM shall conduct himself in accordance with the established customs and usages approved by the district council and in accordance with the rules, laws, and regulations that district council may issue from time to time. Another term provided that the CM and others shall be liable to removal from their offices by the order of district council if that body was satisfied that any of them did not discharge his duties properly or had been acting in a manner prejudicial to the interests of the CMship or the district council in general, or had been conducting himself with indecorum, and such order passed by the council would be final. Therefore, after April 1953, the respondent continued in the office of CM by virtue of this confirmation by the district council. In 1955, there was some modification of the terms which was communicated to the respondent on August 9, 1955. The respondent was informed that he would continue as CM as long as he was not removed from the CMship by the order of the district council for any lapse on his part. He was to submit to the directions of the district council and to obey all orders issued by the chief executive member or any officer of the district council empowered to act on behalf of the chief executive member. The respondent was to conduct the affairs of the Ilaga according to the existing customs and customary laws as approved by the district council and in accordance with the rules and regulations which the district council had enforced or might enforce in future. Provision also made for the judicial powers of the CM in accordance with the United Khasi Chente Hills Autonomous District Administrative Justice Rule 1953. Besides, there are certain other terms which respect to financial matters. The consequence of this order was that the respondent's term as CM was to continue as long as he was not removed from that office for any lapse on his part. The position, therefore, that emerges on a consideration of three orders of 1951, 53, and 55 is that the respondent was holding the office of CM by virtue of his appointment in the first instance by the governor and its later confirmation by the district council on terms which had been communicated to him and was thus no more than an administrative officer appointed by the district council by virtue of such. Now it is, my lord, Supreme Court clearly held that he is appointed by the governor and confirmed by the district council. Therefore, he exercised all his powers from the terms of his appointment letter. And he has to perform these customary authorities as well as the judicial bodies. Now, therefore, he can be removed. Now, therefore, what is his status? Supreme Court say that he is not higher than the administrative officer of a council. Because of the nature of the relationship is under it is in the as per the statutes, but under the 6th statute.
So there's a fiduciary relationship.
Yes, the fiduciary relationship or the jurial relationship between the council and the chief is squarely governed by this statutory. In the principle is master and servant relationship. Therefore, from the beginning, I say that the status which he enjoyed prior to 1950, Constitution of India, is absolutely different from the one now he enjoys. Now, therefore, he becomes the employee, one of the officer of the district council. Supreme Court say. Now, number 10, man, is important. Man. This position apparently continued till 1959 when we come to the incidents which culminated in the order of July 7, 1959. We are not concerned in this appeal with the merits of the action taken against the respondent, nor are we concerned with the question whether there were sufficient reasons for the exit committee to take the action which it did against the respondent. We are only concerned with the power of the exit committee of the district council to take any action at all in the matter of the respondent's removal from the office of the CM. The High Court has taken the view that the appointment and succession of a CM was not an administrative function of the district council, and that the district council could only act by making a law with the assent of the governor so far as the appointment and removal of the CM was concerned. In this connection, the High Court relied on paragraph 3(1)(g) of the 6th schedule, which lays down that the district council shall have the power to make laws with respect to the appointment and succession of chiefs and headmen. The High Court seems to be of the view that until such a law is made, there could be no power of appointment of a chief or same like the respondent, and in the consequences, there would be no power of removal either. With respect, it seems to us that the High Court was read for far more into paragraph 3(1)(g) than is justified by its language. Para 3(1) is in fact something like a legislative list and enumerates the subjects on which the district council is competent to make laws. Under paragraph 3(1)(g), it has power to make laws with respect to the appointment or succession of chiefs or headmen, and this would naturally include the power to remove them. But it does not follow from this that the appointment or removal of a chief is a legislative act, or that no appointment or removal can be made without there being first a law to that effect. The High Court also seems to have thought that as there was no provision in the 6th schedule in terms of Article 73 and 162 of the Constitution, the administrative power of the district council would not extend to the subjects enumerated in para 3(1). Now, para 2 and 2(4) provides that the administration of an autonomous district shall vest in the district council, and this is, in our opinion, is comprehensive enough to include all such executive power as are necessary to be exercised for the purposes of administration of the district. It is true that where executive power impinges upon the rights of citizens, it would have to be backed by an appropriate law. But where executive power is concerned only with the personnel of the administration, it is necessary that even though it may be desirable that there must be laws, rules, or regulations governing the appointment of those who would carry on the administration under the control of the district council. The 6th schedule vested the administration of the autonomous districts in the governor during the transition period, and thereafter in the district council. The administration could only be carried on by officers like the CM or chief and others below him, and it seems to us quite clear, if the administration was to be carried out, as it must, that the governor in the first instance and the district councils after they came into existence would have power by virtue of the administration being vested in them to appoint officers and others to carry on the administration. Further, once the power of appointment falls within the power of administration of the district, the power of removal of officers and others so appointed would necessarily follow as corollary. The Constitution could not have intended that all administration in the autonomous districts should come to a stop till the governor made regulation under paragraph 19(1)(b) or till the district council passed laws under para 3(1)(g). The governor in the first instance and the district councils thereafter were vested with the power to carry on the administration, and that, in our opinion, included the power to appoint and remove the personnel for carrying on the administration. Doubtless, when regulations are made under paragraph 19(1)(b) or laws are passed under paragraph 3(1) with respect to the appointment or removal of the personnel of the administration, the administrative authorities would be bound to follow the regulations so made or laws so passed. But from this, it does not follow that till the regulations were made or the laws were passed, there would be no appointment or dismissal of the personnel of the administration. In our opinion, the authorities concerned would at all relevant times have the power to appoint or remove administrative personnel under the general power of administration vested in them by the 6th schedule. The view therefore taken by the High Court that there could be no appointment or removal by district council without a law having been first passed in that behalf under 3(1)(g) cannot be sustained. In this case, the district council, when it confirmed the appointment of the respondent, laid down certain terms by virtue of its power of administration, and so far as the respondent is concerned, those terms would be govern the related relations between him and the district council in respect of matters including his removal from the office of the same. As pointed by this court in such and such, the conditions of service of a government servant appointed to a post are regulated by the terms of the contract of employment. Express or implied, well, it is important, express or implied, and subject to by rules applicable to the members of the particular service. In the absence of such general rules, the particular terms offered to a particular officer on his appointment would govern the relationship between the appointing authority and the persons appointed in that particular case. It would therefore be wrong to hold that the respondent could not be removed from his office after his appointment in accordance with the terms on which he was appointed. On the view taken by the High Court, even the appointment of the respondent would be illegal, for there was no law to support that appointment at the relevant time. But as we have said above, the governor and later district council being vested with the administration of the district councils, autonomous districts would be entitled to appoint personnel for carrying on the administration, and the power to appoint would include from its very nature being inherent in it. And it is very important, inherent in it. The power of removal.
If I may interrupt, Manoj, what my learned friend is reading is in context with the Act of 1959. Manoj will kindly see. This has already been annulled, Manoj.
But he can respond.
You'll get your chance to
Yes, he can respond.
I'm just showing the court notice.
Yes.
Whatever 59 Act is there, that has been already annulled by way of this 2007 Act.
I'll come. But being inherent in it, the power of remover from it can hardly be contended that though the appointment might be made, the authority making the appointment will have no power to remove a person once appointed. In this particular case, there can be no difficulty whatsoever, because when the district council confirmed the appointment of the respondent, it laid down the terms on which the appointment would be held, as well as the terms on which the respondent would be removed from the office in which he was being continued. Nor can it be said that the appointment in this case was by the governor, and thereafter by the governor would alone remove him. For the notification of March 1951 made it clear that the appointment made by the governor was provisional and was subject to confirmation by the district council when it came into existence. The district council in fact confirmed the appointment of the respondent in April 1953, and so in law the appointment of the respondent was by district council, and therefore it would have the power to remove him. Besides, if, as the High Court thought, the appointment of the respondent was invalid, it would invariably follow that he had no right to ask for a writ under Article 226. If the appointment was bad, he had no legal right and he cannot complain against his suspension. We are therefore of the opinion that the respondent, being an officer appointed to carry on the administration by the district council, could be removed by it in accordance with the terms and conditions of his appointment. It is very, very clear, madam. Therefore, madam, the nature of his appointment is very, very important. Apex Court said he is the administrative authority, district council administrative authority, and he is the officer of that administration. Now, his relationship between the appointing authority and the council is appointing authority is the district council, and their relationship is governed by the rules and laws if in existence. If not also, by virtue of the fact that council is the appointing authority, he comes under the umbrella of the administration, and therefore the condition of his service, terms and condition of his service is very paramount. So on the basis of the terms and condition of his appointment, he can be removed. Now, I would come to that last portion when my lord may come to paragraph 14 of that judgment, 59, where my colleague has pointed out.
Yes.
Paragraph 14, the next page.
Yes, yes, 14.
Yes. Before we part with this case, we would like to point out that the law has been passed, namely the United Khasi Chinte Hills Autonomous District Appointment and Succession of Chiefs and Headmen 1959, which came into force in October 1959. It deals with the appointment of chiefs and headmen as well as under their removal and suspension as a punishment. The word chief includes the same lingdo, etc., and the respondent therefore would be chief within the meaning of this act, and further action may be taken accordingly. Now, the last, my lord, Justice Subarao, he's a order, my lord. I agree with the conclusion, but I have considerable and serious doubts on the question whether, when the Constitution confers on an authority power to make laws in respect of a specific subject matter, the said authority can deal with the same subject matter without making such a law in its administrative capacity. I would therefore prefer not to express any opinion on this sub-question, but I agree with the other two reasons given by my learned brother justices, namely, if the respondent's contention were to prevail, the order of appointment would itself be bad, with the result that the CM would not have any right to the office. On October 16, 1959, an act known as the Census 1959, District Council to remove a CM, and as the was passed, and therefore there is now a valid law empowering the District Council to remove a CM. And as the inquiry in question is only at its initial stage, it can thereafter be validly conducted under the provision of the said Act. Well, therefore, I would apprise that this Supreme Court entered the judgment not on the basis of the 1959 Act, but by virtue of the fact that Council is appointing authority, and Council has the inherent power to appoint and remove and suspend. Therefore, the action taken by Council is governed by the terms of his condition. However, in view of the fact that the Act has arrived now, Council is empowered to take action in accordance with the 1959 Act. That is the thing. Therefore, I want to emphasize two here, my lord. One is, he is only an administrative officer.
Yes.
Number two, my lord, he can be removed on the terms and condition of his appointment.
Yes.
And number three, District Council exercise the inherent power, being appointing authority.
Yes.
Now, may I take the next judgment which I mentioned there, my lord. Liberis MCM versus KGTC, the next flag.
Yes.
And relevant para, my lord. Para 39. Here was the same chip case, the suspended remover.
Para 39.
39, my lord.
Yes.
So here the Guwahati High Court held that how he can be removed, in which manner, under which proceedings. Well, therefore, his election is completely separate. Removal, suspension is completely different from his election. Okay. Election Council has nothing to do. And now, 39, my lord. Coupled with the above, there may be an occasion when a CM is suspended in terms of clause P of subsection 1 of section 6 for not following any law, regulation, rules, and resolution passed by the Council. Would such a violator of law be required to be reinstated as CM for the purpose of enabling the District Council to hold an inquiry or disciplinary proceeding and remove the CM from his office? The answer to this question has to be undoubtedly no. For in the light of the pronouncement of the Constitution Bench in T. Ghazi case, supra, the CM is nothing but an administrative officer and can be removed by drawing disciplinary proceedings. So he can be removed by disciplinary proceedings.
Okay.
Therefore, reference to the, my lord, other authority is not contemplated by the law. So therefore, he falls within the umbrella of administration. Therefore, he can be removed by way of drawing up disciplinary proceedings. But now, with regard to the, my lord, therefore, I would come to the nature of his appointment. My lord, we come to his sanad.
Yes.
Sanad is available, page number, my type copy 23. Page 23, the translated copy.
23 of the...
Of the writ petition.
Yes.
And this is important. Now it says number 2. I may emphasize number 2.
Yes.
And number 9 and 11. To save the time. He says number 2. You shall be under the administration of the KGTC, and you should abide and follow the orders issued by the Executive Committee or any officer duly authorized in that regard, and you are to consult them in the event of any difficulties. So here one mandate is that he has to follow the rules and regulations, acts, and order of the council. Therefore, when it comes to, my lord, that relationship, statutory relationship, because the council cannot invade the customary territory. He enjoys, my lord. Council cannot enter. But now, here, my lord, the district council passed a law, my lord. Therefore, he has to follow that one. Number 9, my lord, we can see the next page.
Yes.
He shall pay 1/8 share from the revenue of the HIMA to this office within the month of April every year. This is one of the key conditions of his appointment. And he never challenges. Now, he cannot say that, no, I'm not liable to pay. Or he cannot say, no, I have paid as a token. There is no concept of token in this condition number 9. He has to pay it. If he has a grievance, he would urge the council that I'm not liable to pay. And number 11 condition is important, madam. Last, the 11th condition. At the bottom, madam.
Yes.
You may be removed or suspended as the CM in the event you violate or allow your third part to violate any of the conditions laid down in this Sanat or any other orders in accordance with the provisions of the Kassil's Autonomous District Council Appointment and Succession of Chiefs since 2007 as amended up to date. So he can be removed and suspended. Now the word suspension, my lord, I'll come later. Now the inherent power, therefore, if my lord come to the Act itself, my lord, the 2007 Act. But this Sanat issued to him stems from, my lord, the sections 5 of the Act.
Which?
By page, my lord, the running page, second volume running page 317. In the same compilation, my lord, they divide into 2 parts.
Is this you the forward?
My lord, in the same one.
Just one.
The Kassil, my lord, Autonomous District Appointment and Succession of Chief, CM, Deputy CM, Electors and Rangpa Shnong of Millennium CMship, 2007.
Do you have given a copy of that?
My lord, it is a major assessment. I can find it.
Me?
Yes, 2017.
Yes.
My lord, we kindly see section 7, section 5. It says, my lord,
Just a moment. Just a moment. Section 5.
section 5.
Yes.
My lord, section 5, appointment and succession of the CM. On the basis of the result referred to in section 4 of this Act, the Executive Committee shall recommend the appointment and succession of the confirmed elected CM to the next session of the District Council, and after approval of the Council, shall forthwith issue appointment order under such terms and conditions as the Executive Committee may provide and not inconsistent with the provisions of this Act. It's under the terms and conditions. The Sanats, it is spelled out. That is, 1, you have to obey the Rules and Regulation Act of Council. Number 2, you have to pay 1 each year, and you can be removed. Therefore, his relationship with the Council my lord, this is section 5 is the bridge between the chief and the council. To have a dialogue, to have a relationship. Right? So therefore, here, council exercises the appointing authority as a head of the administration. Now, therefore, this appointment, the section 5 itself has the implied power to remove him, to suspend him. That's what the Supreme Court said in Ghazi case also. I'll cite other judgments also. Okay. Now, section 7, Lordship kindly read down the section 7. Section 7 only confines to, my lord, the suspension mentioned is with regard to, my lord, if the council wants to suspend the chief by way of punishment, then section 7 is relevant. My lord, can you see section 7?
Yes. Section 7.
Section 7. My read, madam. Term of office of the CM. The CM shall hold office during his lifetime from the date of his appointment. However, in the event of any complaint against the functioning of the CM, which prima facie discloses that, my lord, I'll come to that, my lord, proviso. First proviso, my lord. Number G, my lord. He is, my lord, may I just read out, my lord, yes. Those. He has violated any of the terms and conditions of his appointment sonnet. Is important. He has violated his lordship, I pointed out. He has lost the confidence, my lord, is not relevant. He has been conducting himself in a manner derogatory to his office, or which may undermine the authority of council. This is also attracted in this very matter. He is also found to be mentally unfit, my lord. This is not related, my lord. He violates any customary right or practices bravely, my lord. Here we are not touching this one. He has been convicted of offence involving moral deputy. It is not involved. He is in discharge, insolvent. It is not related, my lord. The exit committee, it says, my lord. The exit committee may, after inquiry, my lord, may after inquiry suspend or remove him from office. Now, he can be removed or suspend after inquiry, it says. Okay. Now, first proviso, provided any complaint against the CM should be first brought to the knowledge and notice of the Darbar Hima. Now, he is emphasizing that this is not followed. I'll come to that later. Provided further, when we read down, my lord, the CM shall not be removed or suspended from the office unless he is given an opportunity of being heard. Now, the last proviso is very clear. Provided also that the requirement of the second proviso shall not apply in the case where the order of removal or suspension is awarded on account of his being convicted of an offence involving moral turpitude. Now, therefore, the word, my lord, here the proviso is very clear. When we read these two provisos, it is very clear that when my lord, if there is a complaint against the chief, then district council wants to suspend him as by way of punishment, not remove, but by way of punishment. Then it says, my lord, council has to invoke that first proviso that should be brought to the notice and knowledge of the Darbar Hima. But here, my lord, if district council wants to place him under suspension pending inquiry, but section 7 is silent. Suspension pending inquiry is silent. Expressly, it is not there. But I would say, my lord, it is, when we read together, it is implied. It is implied. Now, therefore, the emphasis given by the petitioner that the invocation of first proviso is paramount, it is not relevant. Okay. Suspension pending inquiry is not there. Therefore, we say this council invoking the inherent power as appointing authority under section 5. Place him under suspension pending inquiry. And now, my lord, the section, my lord, when we read section 18 of the Act,
yes,
the concept of, my lord, pending suspension inquiry is already there.
Section
18. With regard to appointment, removal, suspension of Rangpashno.
That's Rangpashno.
I'll come to that, my lord. Yes, I'll come to that, my lord. My lord, section 18, Lordship, kindly see. And, my lord, subsection 2.
Yes.
At the bottom, my lord. An appeal against any order passed under subsection 1 above shall lie to the executive committee whose decision shall be final, and every such appeal shall be filed within 30 days, filed within 30 days from the date the order is communicated or known to the party or parties concerned, accompanied by the petition, fee as may be prescribed by the executive committee. Notwithstanding anything contained in subsection 1 above, executive committee may remove or suspend any Rangpa Shnong, if in its opinion is liable for taking action under any of the clauses of subsection 1 above, and the order passed by the committee in such cases shall be final. Provided that Rangpa Shnong shall not be removed or punished under section 18.1 above unless he is given an opportunity of being heard. Provided that the requirements of the above proviso shall not apply in the case where the order of removal or punishment of suspension is awarded on account of his being convicted of an offence involving moral turpitude. Now, it is important, Roman 2, in the case of order of suspension pending inquiry. So, Rangpa Shnong, my lord, the concept of pending suspension pending inquiry is already there. Whereas for the chief, under section 7, it is not there. Therefore, my lord, it is implied. Section 5 being appointing authority, it is implied. It is implied, my lord. They have the power to place him in the suspension pending inquiry. I will come to the judgment, my lord. I would come to the other judgment which we made a compilation. My lord, so this Euron versus State of Meghalaya, my lord, delivered by Guwahati High Court.
This compilation you have not given
Pagination.
which
The third, my lord, the third flag, Your Lordship, can
case number. What's the case?
my lord, so this Euron.
So this Euron.
Yes, my lord.
Yes.
My lord, in this case, what happened? There is an act, Wahadatar Act is there, passed by District Council. But there is no provision for suspension removal. And he was suspended. Therefore, he came before the as well Guwahati High Court and said that District Council has no power to suspend, therefore suspension order is wrong. Now, the Guwahati High Court elaborately considered the matter and say that the Wahadatar Act, yes, there is a silent in the Wahadatar Act. But the Parent Act, 1959 Act, there is a provision for suspension pending inquiry. Therefore, when the Special Act, Wahadatar Act is a Special Act,
Yes.
whereas the Succession of Chief and Appointment Act 1959 is a General Act. Therefore, when the Special Act is silent, one can be reverted back or relied to the Parent Act, or Parent Act can govern that one. And apart from that,
Who is that distinction given?
my lord, I'll come to that. And moreover, Guwahati High Court said that, my lord, by virtue of General Clauses Act,
General Clauses Act.
yes, power appointing authority has the power to suspend. My lord, we come to relevant para 6, my lord.
Yes.
My lord, para 6. It says that before proceeding further, it may be straightaway be noticed that the scope of subclause 2 of the third proviso to section 6 of the Act of 1959 came for consideration. Madam.
Yes.
Before the Apex Court in Khasi Hills, Autonomous District Council versus Charleston Sotun, 2002, Volume 8 SCC, and it was held therein that Section 6 of the Act contemplates that while removing or suspending CMs referred to therein, an opportunity of being heard is to be given, but the said proviso is not applicable in cases of suspending pending inquiry. As noticed earlier, the basic contention of the petition is that the Wahadatar Act is a special law governing the power of removal of the Wahadatar of the Confederacy, and when this law does not contain any provision for suspension pending inquiry, the question of invoking the provisions of the Act of 1959 does not arise. A comparative reading of both the Wahadatar Act and the Act of 1959 will indicate that the former Act is apparently enacted to deal exclusively with the election of the Sheila Confederacy, while the later Act is meant for all the ilakas, including the Sheila Confederacy, except the procedure for electing Wahadatar in the Sheila Confederacy. The term Wahadatar is defined by Section 2H of the Wahadatar Act to mean a chief of the Sheila Confederacy. Section 3 is about the Wahadatarship and the term of the office, whereas Section 4 prescribes the person to conduct the election. Then Section 5 stipulates voting by secret ballots and a simple system, while Section 6 prescribes the manner in which the electoral roll is to be prepared. Sections 7, 8, and 9 are about the electoral rolls, preparation of samples, ballot papers, etc. by the Executive Committee and the qualification for electors respectively. Section 10, 11, 12, 13 deal with the method of voting, time and hours of voting, recording of votes, and disqualification for wadadarship respectively. Then there are Section 15, 16, 17 till 21, which deal with the procedure and the manner in which the election to be conducted. This makes to Section 22, upon which heavy reliance is placed by the Learned Counsel for the petitioner in asserting the impugned order of suspension. As the construction of this provision is likely to have a direct bearing on the outcome of the writ petition, the same is reproduced below. Duties of the elected candidate. Now may I come to 7. Though all the provisions of the Act, except for Clause 5 of the Section 22, undoubtedly are concerned with the manner and the procedure for conducting the election to the office of Wadadar, the reference made to removal of the wadadarship provided for in Clause 5 cannot be lost sight of, and seems to convey the idea that the Wadadar Act is being intended to be an exhaustive code for regulating the election as well as the removal of the Wadadar, and no other law is enacted by the legislature for this removal. However, as the preamble to the Act of the Act 1959 indicates, this Act has also enacted to make provisions for the appointment and succession of chiefs and headmen. Section 2A of this Act also, among others, includes Wadadar as one of the chiefs of any ilaka. What is ilaka is defined in Section 2H to mean any administrative unit in the district specified in Appendix 1, 2, and 3, or any other administrative unit to be constituted and declared as such by the Executive Committee. Thus, two types of ilakas are contemplated by this Act, namely the ilaka already specified by the Act in Appendix 1, 2, 3, and an administrative unit being constituted and declared by this to be so by the Executive Committee of the Council. The name Shila Confederacy, madam. I may skip that one. Remover Section 5, Section 6 was quoted, madam. Yes. Remover is a chief may be removed from office or suspended by the Executive Committee in its opinion if he violates, madam, this Section 6 is the parent act. Okay. Parent act, madam. And the other page, my lord, in that Roman 2, in case of order of suspension pending inquiry. So that is what the Parents Act provided. Now I would come down to 8, my lord. Clause 2 of the third proviso to Section 6 of the Act of 1959 provides that Executive Committee is endowed with the power to suspend a chief pending inquiry against him. There can be no dispute that the Wadadar Act is a special law, whereas the Act of 1959 is a general law, providing comprehensive provisions for dealing with situations not contemplated by the special law, which is basically concerned with the procedure for and the manner in which the election to the office of the Wadadar is to be conducted. There is no dispute at the bar, nor there be any, that the Act of 1959 does not repeal the Wadadar Act. The settled law is that there is a presumption against repeal by implication, and the reason of this is this rule is based on the theory that the legislature, while enacting the law, has a complete knowledge of the existing laws on the subject matter, and therefore, when it does not provide a repealing provision, it gives out an intention not to repeal the existing legislation. As already noticed, the provision of the Wadadar Act do not contain the power of suspension pending inquiry, and all it said is that a candidate duly declared elected is liable to be removed at any time by the order of District Council if it is found that he is not discharging his responsibilities. Undoubtedly, under the special law also, there is already a power vested in the District Council to remove a chief on the ground specified therein. But the procedure for removal of the chief is not laid down therein. On the other hand, Act of 1959 elaborately provides for a number of additional grounds for removal of the chief. Secondly, an express power is also conferred by the general power for suspension of the chief pending inquiry. But both the laws are passed by the competent law-making authorities within a span of 3 years of each time. In my opinion, there is hardly substantial repugnancy or inconsistency between the special law and the general law on the power of the removal of the chief by the Executive Committee. The principle that prior, particular, or special law is not readily to be impliedly repealed by the later general enactment is explained by the court in such and such manner. Number 9. Thus, a law applicable to locality or a class of cases or individual is a special law, which in this case is the Wadadara Act, as distinguished from the general law, which is the Act of 1959, which applies to the whole community or particular community. If the general law, by its own terms, recognizes the existence or continuance of the special law on the subject, no question of inconsistency or repeal of the special law can also arise. In the case at hand, Act of 1959 provides for the power of suspension of chief pending inquiry against him, which is not provided for in the Wadadara Act. We are not, in the case at hand, concerned with the power of removal. We are rather concerned with the power of suspension. The provision with respect to the power of suspension is for the first time engrafted in the Act 1959 by a competent legislature, and there is no conflict or repugnancy between the provisions of Wadadara Act and the Act of 1959. In other words, full effect can be given to both the provision, as there is no mutual irreconcilability between them. More so, when the Act of 1959 does not render compliance with the Wadadara Act impossible, nor does compliance with the former necessarily and automatically involve violation of the latter. In the view that I have taken, answer to the question as to whether the Wadadara Act is an exhaustive code must be in the negative. The Wadadara Act does not emphasize the power of suspension of the Wadadara chief pending inquiry. That being the legal position, I hold the provision of the Act 1959 concerning the power of suspension of a chief are also equally applicable to the office of Wadadara in the Confederacy of Shilla. That apart is important, my lord. Under the General Clauses Act, the power to appoint carries with it the power to dismiss. Power to dismiss, the next page, power to dismiss or remove, also the incidental of suspension pending inquiry. Under general, in my opinion, such a power is inherent. Here was inherent.
Yes.
In my opinion, such a power is inherent when the power of removal appointment is conferred upon an authority. I may fortify it in my view by the observation of Apex Court in Pratap Singh case Supra, where it has been held that if rules do not invest the government with the power of suspension, the power of suspension, a government servant is vested with authority which appoints the government servant in view of Section 16 of the General Clauses Act 1897. Though the aforesaid principle is laid down in the context of the service case, I do not see any reason as to why such salutary principle should not be held applicable to the post of Wadadara, which is also a public post. Therefore, here my High Court held too that Wadadara Act, there is a silence of suspension pending inquiry, but general law can be applied and 59 Act is applied. Now, leaving aside these two acts also, High Court say that by virtue of the General Clauses Act, they have the power to appoint. Appointing authority can exercise power to suspend and remove pending inquiry. Yes, and that power is inherent in nature. Now, the Meghalaya General Clauses Act, my lord, the last flag, my lord, kindly see in that compilation. General Clauses Act. My lord, Meghalaya General Clauses Act. In the last flag, my kindly see, Lordship, can you see section clause 30? It says, madam.
Interpretation and General Process Act.
Yes, madam. Of the Meghalaya General Clauses Act. Meghalaya Interpretation and General Clauses Act 1972.
Yes.
Clause
This
13.
General Process Act, every state can have its own General Process
Yes, yes. Every state also. And General Clauses Act also there. And similar, madam. I'll please that General Clauses Act also. Madam, can you see clause 30?
13.
30, madam. 30.
Yes.
Madam. It says power to appoint to include power to suspend or dismiss. It says whereby any enactment, a power to make any appointment is conferred, then unless a different intention appears.
Reading.
my lord, clause 30, my lord.
30, chapter 5.
Yes, chapter 5, my lord. Chapter 5, clause 30.
Yes. Yes.
My lord, whereby any enactment of power to make any appointment is conferred, then unless a different intention
Where is that?
appears
You're reading?
at the bottom, my lord,
Sorry.
chapter 5, at the bottom.
Yes. Please.
My lord, unless different intention appears, the authority having for the time being power to make the appointment shall also have power to suspend or dismiss any person appointed, whether by itself or by any authority in excess of that power. Therefore, my humble submission is that, my lord, leaving aside section 7 of the Act, section 5, which empower this council as appointing authority, that very includes power to suspend pending inquiry. So the general clauses echo also, my lord.
Yes, Mr. Sir, we'll continue
Yes.
tomorrow.
Yes.
Tomorrow? Huh?
Matter has been lingering on.
It's not lingering.
No, but this is a fact.
Very fast.
Because we have resisted. My lord, they have resisted the interim order, my lord. That's
20
why.
days affidavit filed and lordship in the middle of the hearing. Only I am asking gap.
Why not tomorrow?
No, I don't know.
No, he will finish his. He'll complete. He'll conclude his.
I'll continue, my lord.
He's concluding. Let him continue.
So let him conclude tomorrow. Maybe, as far as you are concerned, maybe day after tomorrow.
No.
Because heard Mr. H.L. Sangresu, Learned Senior Counsel and Special Counsel for the respondent KHADC. Hearing is, argument is not concluded and will continue tomorrow. List accordingly.
Give the approach.